All right. Good evening, everyone. Hope people are doing well on this beautiful autumn day in Windsor or Toronto or wherever you may happen to be. So last time on Tuesday we saw a trial. We talked about the order in which a trial proceeds: the plaintiff's case, defendant's case, what happens with all the witnesses, and so forth. And then we looked at an actual trial, the fascinating high stakes matter of 733 LLC versus Scottsdale Insurance. Today we're going to talk about the whole question of juries, right, which is kind of the last procedural item that has to be addressed in a civil action before the trial can actually take place. And it can actually be quite a major form of a procedural motion that creates a lot of high stakes contest between plaintiff and defendant, and that will determine whether or not a jury will be part of a trial or not. So what is a jury? Let's get some slides going here. Okay, so a jury is a panel of randomly selected citizens whose role it is to help adjudicate a trial. And it's a six-person jury in a civil matter, as opposed to 12 in most criminal cases. Okay, most people have got it, and this is basically the case whether we're talking about criminal procedure or civil. The judge's role, as a trained legal expert, obviously, is to decide questions of law, whereas the jury, in principle, is deciding questions of fact. So, can anyone remind us from criminal law what does the Charter say about the Charter of Rights and Freedoms say about jury trials in criminal matters? Okay, you do have the right to a jury. Do you always have the right to a jury trial for any criminal charge? Okay, just sticking on the criminal side for a second. Okay, so yeah, not necessarily in military tribunals. Depends on the statute. It also depends on the charter. The charter is specific with regard to what type of charge entitles you to a criminal jury trial, and that's if it's a charge with where you're facing imprisonment for 5 or more years. In those cases, you have a right to a jury trial in the criminal matter. On the civil side, there is no such constitutional right in Canada. Unlike the Americans, they have the right to a civil jury trial as a constitutional matter. So criminal and civil are different. In civil, as we said, it's half as large. It's only 6 people, and only 5 of them need to agree in order to make to reach a certain verdict. And because we don't have the constitutional right, most trials, civil trials in Ontario, do not involve a jury. It's only 60 or 23% which involve a jury. And in some matters, jury trials are never allowed, right? So small claims matters, for example, you would never see a jury, and that's in the Small Claims Act. Why do you think that is? Why would you never have a jury for a small claims matter? Okay, too expensive. Yeah, takes more time. What's the overall principle of civil procedure that makes us care about how much time and money is involved when relative to the amount of money that's being proportionality, right? So juries also always make proceedings take more time and money because the lawyers have to spend time addressing the judge as well as addressing the jury, and you have to explain things in a different way, a more kind of elementary way when there's a jury, which is your audience, as opposed to just a judge. But when the matter is significant, and a lot of money is at stake or important rights are at stake, that is thought to be justified. But when it's relatively insignificant, in the case of small claims, it would be disproportionate. Another circumstance in which you will never see a civil jury in Ontario is anything to do with family law or divorce. Why do you think that is? It's not really a proportionality concern, right? I mean, family law can involve a lot of money, and it can involve issues which are extremely important to the well-being of the parties. Gender bias, says Joy. Okay. So the bias is an interesting piece. And obviously it comes up when we talk about jury selection in criminal law as well. You may remember the Colton Boushey matter. It's been still very much a live issue about how different forms of bias, be it gender bias or racial bias, might affect the way we think about judges and juries. But it's not a clear-cut analysis, right? Because if we have to the extent these problems affect the system, and of course they do, they are arguably just as likely to affect judges as they are to affect juries. So with family law, it's not really about bias, the concern. Just looking through the comments here. It actually comes down to privacy, right? So juries you're entitled to a jury of your peers, which is to say the jury will be drawn from people living in the same municipality as that in which the trial is occurring. And family law matters are thought to give rise to higher privacy concerns and other things. So it's going to be effectively your neighbors constituting the jury for your family law matter. That's considered an excessive infringement on people's privacy. Okay, so putting aside small claims court and family law, in most other civil matters, if the parties both want there to be a jury, both plaintiff and defendant want there to be a jury, then there will be a jury. If both sides don't want a jury, then it will be done by judge alone. So in many areas of law, intellectual property law, commercial litigation, no one really wants a jury, so there won't be a jury. Your first readings today, are about what happens if the two sides disagree about whether or not there should be a jury. So you had Section 108 from the Courts of Justice Act, and then you had Rule 47. So if you put these together, it's kind of complicated. It's an example of roundabout wording. If you were drafting this from scratch, you would not word it this way. It looks like this because we started off with a very strong right to a jury trial, and then exceptions were added, but the exceptions were just kind of like tacked onto the rule instead of rewriting the rule from scratch. It's an egregiously common phenomenon with rules that they're very difficult to understand because they kind of bits and pieces were added to them over time. So anyway, this slide is an effort to make sense of this. So the question is, should there be a jury or should it be a trial by judge alone? So the default is it'll be by judge alone, right? It will be by judge alone unless any party delivers a jury notice before the close of pleadings, right? So way back at the beginning of the case, you've got to start thinking about this on behalf of your client because you've got to issue that before the close of pleadings. If no one does so, then the matter will be tried by judge alone. If someone does, then we ask whether any other party moves to have that jury notice struck out, which is under 47.02. If no one moves to have it struck out, then that means effectively everyone agrees that there should be a jury and the trial will be heard by that judge and jury unless and until the judge chooses to strike the jury, because that is a residual power that the judge has. If someone does move to have the jury notice struck out, then we have to have our legal test, right? We have to look into the merits of the jury. And the basic test there is whether the moving party establishes that justice to the parties will be better served by striking the jury. And the Cowles versus Balac case will explain that test. If so, the jury is struck and it's heard by judge alone. If not, then we proceed with the jury unless and until it gets struck by the judge. So let's talk about this case, Cowles versus Balac. So the events that gave rise to this case occurred at the African lion safari. But anyway, so these people in this case were attended African lion safari, and it's basically a drive-through zoo, right? You stay in your car, the animals are all around. sort of jungle safari type animals, and you look at them, you take pictures of them, but the rule is you do not roll your window down. So suppose I do visit the African lion safari and I do roll my window down and an animal bites my hand off and I sue. What is the and I sue in tort? What's the legal defense for African lion safari? What's the legal doctrine that reduces or eliminates the tortious liability of a defendant when a plaintiff does something like rolling down the window? It's contributory negligence. The plaintiff contributes to their loss through their own negligence. Okay, so looking at this case, it's called Cowles versus Balac, and Cowles and Balac were the two people who were in the car. But the real action is, Cowles and Balac on one side and their insurance company on the other. And maybe someone can summarize for us why Cowles and Balac were suing African lion safari.
So basically what happened was they were on the safari, and while they were driving through, a tiger or group of tigers attacked the car, and somehow, one way or another, the windows got rolled down and the tigers got in the car and mauled them both.
Yes, that's right. That's exactly it. And they were very, very seriously injured by this, to the extent that their damages, in the case of Balac, I think, were $1.7 million. So the tigers got in the car, right? And the trial judge found that the African lion safari had been negligent in various ways in terms of how they were handling these animals. They removed one of the cubs from this kind of pride of tigers, and that gets them riled up, apparently, if you remove one of their cubs. And none of those findings of negligence were appealed. But everyone agrees that no matter how negligent the defendant was in dealing with the tigers, and no matter how riled up the tigers were, there is no possible way that they could have mauled the plaintiffs unless the window was open. And it was also agreed by everyone that the window was closed when they came into the car park, because they've got people at the front gate making sure your window is closed as you roll in. So how the heck did the window get open? Because it must have been open. That's the central factual dispute in this case. So the African lion safari, what's their story about how the window got open? Right. Rolled it down to take a picture or to feed the tiger, right? It's very tempting. The adorable animals are outside. It's a nice summer day. Wouldn't it be cool to feed them or pat them? This happens all the time. Well, I don't know if it happens all the time, but people are at least tempted all the time. That's why they have signs everywhere in the park saying don't do it. They have some backup for this story, right? They have, in fact, 5 different witnesses who testified about statements allegedly made by Balac or Cowles, the plaintiffs, about how the attacks occurred. And these suggested that Cowles had intentionally lowered the passenger window in order to take a photograph or to feed the tiger. So what's the formal deficiency in this evidence? What's the one word that summarizes the problem with this evidence about how the window got rolled down? It's hearsay, exactly, right? This is what other people said Cowles said to them. Hearsay. So it's hearsay, but it's pretty good. It's pretty good for hearsay evidence, right? As hearsay evidence goes, because it includes the paramedics. Paramedics are probably have no reason to lie if Cowles admitted to the paramedics that she rolled down the windows, and Cowles' own aunt, who again you'd think would be on her side. So if she's saying that Cowles admitted rolling down the window, that's pretty persuasive as far as hearsay goes. Okay, so that's the defendant's version. The plaintiffs have a different version on this crucial fact, which comes in at paragraph 22. They say, okay, so we were going through in our 1988 Honda Prelude, and the Honda Prelude is equipped with luxurious power windows, and but it's also got the manual clutch. So the Tigers were hurling themselves at the car in a vicious rage, and Balac got jostled, and he came into contact with the window. He just like hit it with his elbow or something, and it rolled the window down. Not his intention. It was a consequence of them being attacked by the tiger. And then once it was down, the Tigers were able to get in. Okay, so this is key, right? Because if they rolled the window down, given that they were explicitly warned not to, that's very powerful contributory negligence, and they'll get little or no damages. Otherwise, the whole thing is the African lion safari's fault, and they're going to get their big damages. Okay, so that's the key factual issue, but that is not what this decision is actually about, right? This decision is about the jury notice. So what happened at trial with regard to the question of the jury?
The judge eventually determined that they were going to proceed without the jury, and there was a bunch of reasons why they came to that conclusion. One of them being that the one of the more disputed was that the length of the trial, but also the complexity of the legal question, and I believe the fact that they were both represented by separate counsel, and the number of expert witnesses that were going to be involved. All that to say that it was much too complex, according to the judge, to have a jury decide these matters.
Okay, great. So that's a good summary, and yeah, we'll talk about the reasons in a second. But just to go back a step, just so we understand where we are in terms of this process, paragraph 28 tells us that the defendant issued a jury notice, the African lion safari, or rather its insurer, and then it was the trial judge who struck it out at the beginning of the trial. Okay. So the trial proceeded without the jury, as Jeremy said. The plaintiffs won $2.5 million in total, and this is an appeal of that trial judgment. Okay, so the case is largely about the legitimacy or acceptability of the trial judge's reasons for striking out the jury, but there's also some bigger ideas here, right, about kind of the epistemology of justice and the extent to which we should be looking to average people from the street, like jurors, to be making legal decisions versus the special expertise of the legal system. And there's some interesting ideas about common sense, especially in the dissent. Okay, so the trial judge's reasons for striking, we've got complexity. They said there was a lot of different expert evidence of different kinds, right? So we had disputed expert evidence on the liability aspects. They had people testifying about, well, what's it like in the driver's seat of the 1988 Honda Prelude? Is it plausible that someone could be jostled through a huge animal hitting the car from the outside to the extent that the window automatically or accidentally rolls down? Medical evidence, of course, about the nature of their injuries. There's also actuarial evidence in this case, expert actuarial evidence. So it's kind of obscure, right? It's actuarial evidence is going to be evidence about money or income of various kinds. And at paragraph 29, this is a long quote from the trial judge here. But what have they lost? Like, where does this 1.7 million come from? What's the bulk of that going to be? Like in a personal injury case, where you get 7-figure damages, what do most of them come from? Rehab will be part of it, but rehab won't be the biggest part. Yeah, time off work, lost wages. That's the big one, right? If you lose your ability to work, or if you lose your ability to make as much as you otherwise would, that's where the damages really start adding up. And so there's actuarial evidence will often be led in personal injury cases about how much income the plaintiff has lost as a result of the injury. And at paragraph 9, we hear that this actuarial evidence is even harder here because the plaintiff is at a stage in life where they have not yet moved into a permanent vocation, right? If I get mauled by a tiger and I lose my ability to be a law professor, it's pretty easy to figure out what my lost income is, right? Because I'm in a collective agreement and everyone knows exactly what I'm going to earn for as long as I'm fortunate enough to keep this job. These people are young. They haven't established their careers. They might go on to be rock stars. They might go on to be janitors. They might go on to be unemployed. So when you're projecting their lost income, you need to do so by taking into account all the possible contingencies about what type of careers they might have had they had the opportunity to pursue them without these injuries. So that's a form of factual complexity, right? And it's a form of factual complexity which is very relevant to the issue of their damages. Okay, so something else that struck the trial judge as a good reason to strike the jury is the length of the trial, right? The counsel estimated at the outset that it would take 6 weeks, right? 6 weeks is a long time to be in a jury box, right? You're there for 8 hours a day trying to pay attention. It takes just a lot of endurance to stick with it and be sharp and be as good on the last of those 6 weeks as you are during the first one. Lots of lawyers involved on behalf of the primary plaintiffs, they say, right? Because it's an insurance case, so we won't get into it, but they're suing and being sued in different capacities. Okay, so for all those reasons, the trial judge strikes the jury. That decision to strike the jury is under appeal. We have here a majority judgment from Justice O'Connor and a dissent from Justice Borens. So this is wonderfully exciting. A dissent. Can you imagine a dissent in a civil procedure case? I think it's still, the only dissent you will find in the entire course. There's relatively few dissents in civil procedure generally. Judges may feel that, compared to constitutional law or something like that. Dissenters, people may feel that it's better to kind of hold their tongues and go along with the majority because, some say that civil procedure does not talk about the most important issues and it's not as fascinating and philosophically rich as other areas of law. I say those people don't have a leg to stand on, but for whatever reason, we don't get that many dissents, so we enjoy everyone that we see. Okay, so let's look at the majority's reasons. At paragraph 36 to 37, and then paragraph 40, we get the key law on a test for a motion to strike or a decision to strike a jury. They tell us first that it's a substantive right and should not be interfered with without just cause or cogent reasons. So substantive here means that it's not just, in a way it is procedural, right? We previously defined procedural and substantive in the sense that, procedural decisions are about what happens in the litigation, substantive decisions are about what happens in the real world. By that definition, it's procedural, right? Because we're just talking about how the trial is going to happen. But the majority nonetheless asserts that this is a substantive right, and here I think they just mean that it's an important right that we shouldn't give up for no reason whatsoever. Paragraph 37, the party moving to strike the jury bears the onus of showing that there are features that merit the discharge of the duty, merit the discharge of the jury. And the final test is whether the moving party has shown that justice to the parties will be better served by the discharge of the jury. So kind of a circular, not particularly helpful test, but that is what the law is. Paragraph 40, it talks about deference. does it mean when an appeal court talks about deference? Respect, okay, deference is respect, but respect for who? Respect for what? Lower courts, that's right. Yeah, so this is all about the circumstances in which the appeal court will be motivated to uphold the trial judge if they can, versus circumstances in which they're less deferential, which they're more willing to substitute their own judgment for that of the court below. And there's reasons why this is a good opportunity for deference, because it's one of those things where the trial judge has an advantage by virtue of having seen the jury, been more intimately acquainted with what type of evidence the parties are going to lead and how the case is going to turn out. Paragraph 43, again, we're still with the majority here. This ground of appeal turns on the proper application of the principle of appellate deference to the way in which the trial judge exercised her discretion. So that's code for O'Connor saying, look, if it had been me, I probably would have done something different, but I think we should defer and let this decision stand, even though it might be wrong. Okay, so we get now into discussion of complexity. And complexity, paragraph 48, is proper consideration in determining whether a jury notice should be struck. It's perhaps the most important consideration, and it's by far the most common reason why courts dispense with juries in civil cases. And there's two types of complexity, right, in a case. A case can be legally complex, or it can be factually complex. So these two types of complexity, which is more important when we're thinking about whether or not we should strike the jury? And the case kind of muddies the waters here, but at the end of the day, as we know from the first poll question, the job of the judge is to make legal determinations, and the job of the jury is to make factual determinations, right? So ultimately, it's factual complexity which is going to be more important, because that's what the jury's job is. But I say the judgment kind of muddies the water, because they say while the trial judge is responsible for determining questions of law and instructing a jury, the jurors have to decide whether and how those legal principles apply to the facts as they find them on the evidence. So the distinction between legal questions and factual questions is pretty clear in principle. It can get muddy, right, when the jury is instructed to make factual findings which refer to a certain legal issue. But it remains the case that if you really want, if you're making submissions about why a jury should be struck, you want to focus first and foremost on the factual complexity, which includes, of course, the complexity of the expert evidence on issues like the actuarial piece. So paragraph 57. O'Connor, for the majority, is basically going to uphold the complexity is sufficient. And paragraph 60, that he goes through the grounds of appeal, which I won't do in detail. I'll just point out a couple of things that are worth emphasizing in the majority's reasoning. There is this idea of a wait and see approach. So this is something which can happen, right? The wait and see approach is where you let the jury stick around from the outset of the trial, and if and only if the things become too overwhelming and too complex for the jury, only then do you strike it. The trial judge had that option. She chose not to. She struck it right at the beginning, but that's on the table as a possible remedy. Paragraph 79, the length of the trial, the anticipated length of the trial can be relevant, right? It's not paragraph 81, I should say. The fact that it might last for a period of time is not enough in of itself, but the length of a trial may be one indicator of the complexity of a case, right? Stands to reason. More time, more cognitive demands, more stuff for the jury to keep straight. So that's the majority judgment in a nutshell. One of the things that we're talking about here, when we're talking about juries, is experts versus lay people, right? Where is the boundary between things which are about common sense and things which require expert legal training? And I asked a couple of questions here in the participation questions about this, and got some great stuff here about what we should be thinking about, or what's relevant to the question of what judges and juries are good at. Where was it? Right. So reasons why juries should continue to have a prominent role in trials. That they provide fresh insight and represent the reasonable standard of the average person. It's 6 people instead of just 1 person. So there's a kind of a wisdom of the crowd involved there. Reflects the society's values, which is true to the extent that we want the justice system and we want our legal outcomes to, remain connected to what average people think. That's important. But then, of course, there's a whole discourse around racism and other forms of bias. And of course, it's not enough in of itself to say judges are racist. You also have to say judges are racist and juries are less racist than judges would be. Often the argument is made the other way, that even if judges are racist, juries are more so, and the same would go for other forms of bias you might talk about. Part of the Constitution and legal rights, yep, it is, although not on the civil side. Some other good stuff here. Yeah, so here's another point which comes in when it comes into bias, right? If you see bias as something which is a minority problem, or a problem that affects only a minority of people, then you're requiring 5 out of 6 to reach a consensus, and maybe sort of the the rotten apple won't have the chance to do an injustice. Whereas if that rotten apple is the judge and the judge is there alone. Okay, so that's one side of it, and then people in the next question got into the other side of this, why juries maybe aren't such a great idea. Jury selection process is tedious, it's expensive, as we know, extends the amount of time and money required to do it. Maybe the biases and prejudices are worse for people on the street than they are for judges. And then again, there's racist on the other side of the same debate, and so on. Okay, and this is interesting, the tactical strategy piece. We'll come to that when we get to the Alan Shanoff article. Okay, so this kind of sets up, the fact that all these big ideas are at play may help explain why we do have dissent in this case from Justice Borens. So, so the dispute between the majority and the dissent is in a narrow level about how to characterize the trial judge's comments, right? Did the trial judge just make this decision to strike for the wrong reasons? And so that's there, right? And Justice Borens sides with the defendant, with the insurance company, says that the trial judge should not have struck and should have kept the jury. And what he does here is he emphasizes what is by far the weakest link in the plaintiff's case, right? At paragraph 129, how did the bloody window come to be open, right? And Borens, I think it's fair to say, finds the plaintiff's story tough to swallow, to say the least. We were just jostled around in this vicious tiger attack so much that our elbows hit the power window button. He doesn't really buy it. And 6 people, Borens points out, reported that Cowles said to them that she opened the window on purpose to take a picture. And even though it's hearsay, Boren said it's enough people, and enough people who had no reason to lie, who have said this, so that we should probably buy it. So he reviews the law. It's basically the same law. There isn't really any dispute between dissent and majority about the nature of the law. But Boren's characterizes the trial judge's comments in a way that suggests she contravened the law. So he points out that the trial judge talked about the legal complexity too much. So he thinks the trial judge has misapprehended or was wrong to talk about legal complexity, because it really should be all about factual complexity from the dissent's point of view. It's an error of law to discharge a jury based on inability to explain the applicable law to it. He says that that's the trial judge's job, is to explain the law, and the trial judge should have just found a way to do it. And the estimated length of trial was relied upon too much. So they talk about the relevance of the criminal context, right? Because by far the overwhelming majority of jury trials are held in the criminal context, and Boren's has heard quite a few of them. He has a high regard, he says, for the intelligence and common sense of juries. I have a high regard for the ability of trial judges to explain difficult and complicated concepts of law and factual issues to a jury. We should not count them out, right? Quoting Chief Justice Dixon, the very strength of the jury is that the ultimate issue is determined by a group of ordinary citizens who are not legal specialists. And that's why they're there, right? So the fact they're not legal specialists is the great thing about them, not a reason to cut them short or find reasons to exclude them from this process. Judges and lawyers have all this great training and experience, but that may in fact blind us to common sense issues. And in this case, the common sense finding, which Boren's thinks the judge was blind to, was that it's completely impossible to believe that they rolled the window down accidentally. And he says the jury would have got that. He says this between the lines, but basically the jury would have reached the common sense conclusion, where the trial judge bent over backwards to not do so. It's really much simpler than everyone else is making out to believe, according to Justice Boren's. He talks in paragraph 192 about things you can do, measures that can be taken to preserve a litigant's right to a jury trial, right? So measures that are available here, right? That if it seems like it's going to be a tough one and it's going to be hard for juries to handle, instead of just getting rid of them, we should see what we can do to keep them in the picture, by like breaking the trial up into different stages. And that's one. Having pretrial conferences, like there's things you can do, and we're not getting into the details of them, but that's where he's coming from. So we're talking now about the Alan Shanoff article, right? This op-ed you read from Law Times. That's this one here. So yeah, what it comes down to, so first of all, has kind of what you'd expect, the objection that juries aren't required to follow the law effectively, which makes sense because they're making factual findings. But he says that they don't give reasons, and ultimately there's a kind of an arbitrariness involved if you turn these things over to juries. It's very, very difficult to appeal a jury verdict. So there's a sense in which doesn't have the same standard of the rule of law and accountability that you get when you have a judge making a decision. He says also that the litigation is very complex. Most jurors are probably unable to fully understand the issues and the evidence. And defendants generally do want juries. and plaintiffs usually don't when it comes to personal injury matters, right? And that, of course, was the case in Cowles and Balac. It was the defendant which brought the jury notice, and then the plaintiffs were trying to get rid of it, although it was ultimately the judge that did so. So what are these tactical advantages? He says that insurers get tactical advantages from jury trials. What are those? Why is it that if you're a defendant's lawyer, like if you're an insurance defense lawyer and you want to increase your client's chance of winning, or reduce the amount of money your client's going to have to pay to settle, it's often good tactical advice to bring a jury notice. Okay, so it increases the cost. That's true, but it increases the cost for everyone, right? I mean, it increases the cost for the defendant as well. So why is it a strategic advantage? Well, I think people are kind of getting here, right? So the defendants have deeper pockets typically than plaintiffs, and even though the plaintiffs in these cases, their lawyers are compensated on a contingency basis, if you can make the process take more time and money, that puts pressure on the plaintiff and their lawyer to settle. And the insurance company has deeper pockets, and investing in this case to deter future claims and to create a reputation for toughness will pay off in the long run for the insurance company. And so that's the argument. The longer trial, a jury trial, is also a longer trial, right? The 6-week trial, if that's a jury, that's often going to be a jury trial. That creates a bigger risk for the plaintiff, because if you lose, then you have lost more of your own time if you're the plaintiff. So that's kind of the general strategic argument for bringing a jury notice on the part of defendants. There are also specific cases, and I think Mallory's comment kind of gets at this. There's certain types of plaintiffs where the insurers are very, very keen to have a jury, because so my wife, before she got into estate litigation, was an insurance defense lawyer. So she represented insurance companies against accident victims. And the kind of tactic or the strategic approach that she was encouraged to take by senior people in the bar was that if the plaintiff has a really obvious injury, has like something like a broken leg where they're going to be visibly injured, or even better, kind of rolling into court on a wheelchair, then you want that person to be heard by a judge, right? Because the idea is that juries are very impressed by conspicuous physical injuries. Juries are much less impressed by invisible injuries. So if a person has a soft tissue injury, or if they suffer from fibromyalgia or its psychological symptoms, or pain, but there's no cast or anything like that, the idea and the belief in the insurance defense industry is that jurors are much less likely to take those cases seriously. So in those cases, the question of a jury is especially tightly fought, because the plaintiffs perceive a strong advantage for having a judge alone. The insurers perceive a strong advantage from having a jury in cases of invisible injuries. Sometimes it's also relevant how the plaintiffs come across, right? And so Mallory said, the jury, hoping the jury will engage in stereotyping, or the plaintiff won't appear well in court. In this case, Dave Balac was an accordion player, and Jennifer Ann Cowles was an exotic dancer. So people with kind of less white collar occupations, it's often thought that jurors are going to be less sympathetic to them, and they're definitely not going to be prepared to award them big damages. So in those cases, the stakes become higher for the jury notice. So this is all kind of the considerations behind the scenes, and if you are an advocate either on the plaintiff's side or the defendant's side, you are going to be giving advice to your client about the question of jury with an eye to how that affects the strategic interests of your client. Okay, so that's kind of Shanoff's argument about this. People are fairly evenly divided about whether to give effect to this, but it may happen, right? As I said, it's happened in a couple of provinces already have abolished the civil jury trial. I think they've also abolished it in England. No, yeah. So in England, you can have a civil jury trial, but not for personal injury. Okay, so I think that pretty much wraps up the jury piece. Let's talk about this number case, right? This 460635 case, also known as Kallinikos. It's just a short case, and we won't spend much time on it. But it was a trial between these two corporations. And the trial judge found that 460. Actually, let me turn my thing back on so everyone knows what case we're talking about here. This case. So the trial judge found that 460 is liable to 100. That's not disputed. But Kallinikos is the shareholder of 460635 Ontario. So this is called piercing the corporate veil, right? As you know from BizOrg or other courses perhaps, where a litigant is trying to sue a shareholder of a corporation instead of just suing the corporation themselves. And what happened is that the pleadings were developed and the allegations were brought only against this corporation, not against Kallinikos himself. And the trial judge nonetheless found that Kallinikos was liable. And that is not allowed. That's what's called a variance, right? Where the pleadings establish a certain set of legal issues, but then at trial, someone attempts to raise an issue which was not pled. And that's what happened here, right? All pleadings established was a case against this corporation, and then only at trial did this corporation seek to establish the liability of Kallinikos. The trial judge issued a judgment which found liability for Kallinikos, and that was overturned because that type of variance is not allowed. So that's basically all I wanted to say about this, right? Variance is not allowed. The issues for trial are defined by the pleadings, and that includes the question of who can be held liable, as well as the question of what the legal issues are. All right, so now we get to Hearn versus McLeod Estate, brand new case, fresh off the presses in September. And this case is all about the appropriate role of a judge at trial vis-a-vis expert witnesses and the evidence. So the plaintiff is this chap, Hearn, Kevin Hearn, best known as a member of the Bare Naked Ladies, a big kind of Canadian alt-rock band in the 1990s. And so Hearn is an art fan, and a fan in particular of Norval Morisseau, who is one of Canada's best-known, internationally renowned Indigenous artists. And Kevin Hearn goes out and buys this painting, which is called Spirit Energy of Mother Earth. Hearn buys the painting from a guy named Joseph McLeod, who's an art dealer, and the understanding was presented as a genuine Norval Morisseau painting. Hearn subsequently concludes that it's a fake. And he's mad. He brings a lawsuit. He wants to sue McLeod. McLeod is dead, so it's against McLeod's estate. So at trial, the plaintiff obviously has to prove that it's fake, and the plaintiff bears the onus, right? So we have the balance of probabilities standard. The plaintiff has to prove that it's more likely than not that this is a fake painting, as well as all the other elements that was sold to him. He actually parted with the money, and so on. So Professor Carmen Robertson is involved in this case. Why was she involved? Okay, expert expert witness. What was she testifying about? What was the issue that led to this expert evidence being necessary? Authenticity, right? Is it a fake or not? Right? Not something that the plaintiff and the defendant can lead their own evidence about. It's a question for an expert whether this is fake or not. So Professor Robertson was the only expert who was qualified as such at trial. Anyway, it's fake, she says. And she has a pretty well-developed point of view on this. She's got a written expert report that she puts in. Trial judge, however, does not buy it. Why doesn't the trial judge buy it? Why does he reject Professor Robertson's evidence? Basically, doesn't think that her analysis is legit. She's got this Morellian analysis. I have no idea what that is. If someone knows what Morellian analysis, any art history people here, maybe not. So anyway, she uses this, or she sort of uses this Morellian analysis. He says that's all bunk. But he is a law professor, and it may kind of come through, right? He's an academic. Because it's probably not your average judge who would do what he did, right? Basically, kind of take it upon himself to look into this stuff and more or less kind of mansplain the whole art criticism thing to her, which does not go over well with the Court of Appeal. So there's a few issues here. There's one issue that the Court of Appeal starts with at paragraph 28, a breach of the rules of natural justice. And this breach of the rules of natural justice touches on an important theme in this course, a Latin phrase that we have used before, audi alteram partem. So what does that have to do here? I mean, what's audi alteram partem here, both sides? How did the trial judge's conduct infringe this principle? Yeah, so the expert was unable to respond. It's the plaintiff. The plaintiff has been deprived of a right here. How is the plaintiff's right to be heard undermined by what the judge did? Because it's not about Professor Robertson's interest or the fact that she's been disrespected, really. Why is the plaintiff lost out? If you were the plaintiff, you're Hearn, right? What right to be heard have you been deprived of? So Professor Robertson is Kevin Hearn's expert, right? So the plaintiff has retained this expert evidence and led this testimony. And what's supposed to happen is that if there's holes or problems in the plaintiff's expert testimony, then the defendant, that's supposed to emerge by the defendant cross-examining the plaintiff's expert, or the defendant bringing their own expert. So you remember from last time when we talked about the order of trial. So we'll just think about how this would have played out in the process of the case, right? So this is the plaintiff's case. Hearn, the guy who bought the painting, says he was ripped off. He has this expert who he knows is going to testify saying it was fake, which builds his case. So there would be an examination of that witness, and she would have submitted her expert report. If her testimony, if her expert evidence is deficient because she's relied on this outdated Morellian analysis when she should have used the critical studies school, as the trial judge says, then that should come out in the defendant's cross-examination of that witness, or in the defendant's case, if the defendant calls their own competing art history expert who says, I think the painting is illegitimate, more so for this and this and this reason. And if either of those things happens, then the plaintiff will have a chance to respond. Right? They'll have a chance to re-examine their witness if those criticisms came out in the cross-ex, and if those criticisms come out in the defendant's case, then the plaintiff will have the chance to cross-examine the defendant's art history witness. So the point is that it's not that this is irrelevant, right? If the expert evidence is flawed because for whatever reason, relying on analysis or whatever, that should come out. But if it comes out only in the trial judge's reasons, you have deprived the plaintiff of the right to respond to it. Because once the trial judge issues their reasons, then it's over. The trial is over. That's why the judge should not be taking that unto themselves. Okay, so we have that deprivation of the plaintiff's right to be heard. And then we also have the sense of the trial judge getting his role wrong, right? He did not, he didn't respect the role of the expert evidence relative to his own role. He's entitled to reject the evidence, right? So it's part of the judge's role. This is a trial by judge alone, no jury. So the judge has to make findings of fact. So a judge can reject expert evidence, but the reasons have to be based on the evidence. And there's a very limited window for judges to conduct their own investigations, do their own reading, otherwise go beyond the evidence in open court in order to make findings of fact. Anyone remember what that's called when a judge uses a fact which was not in evidence, where a judge uses something that they know or something that's from the news? Judicial notice, exactly, taking judicial notice. Thanks, Kamal. So that's a narrow thing that a judge can do, and in quite narrowly defined circumstances. This judge is taking way too much notice of things which are not in evidence, namely things that he just went off and read. So he went off and did this, but instead of congratulating him for his scholarly bona fides and his willingness to put in the work, we find here that he has gone beyond his role and committed an error justifying overturning on appeal. So the reasons for rejecting expert evidence must be rooted in the evidence before the trial judge. And paragraph 30 explains this pretty well. The trial judge rejected her expert evidence on a contrary theory that was not put to her and on which she was not cross-examined. He drew on resources that were not in evidence but were obtained by him outside of the courtroom, and stepped out of the impartiality of his position as trial judge and descended into the arena. So the arena metaphor is great. We also talk about, I said that in the conventional civil action, the judge is up here in the mountains, right? Not down here in the valley. We do not have an inquisitorial justice system. We have an adversarial justice system, meaning that the judge has to reach their conclusions based on the facts and the legal arguments advanced by the parties in open court. So it's both about the proper role of the judge and also about the fact that by doing this research and having it not be in open court, you've effectively short-circuited the plaintiff's right to challenge it. Okay, so that should be fairly clear. I think we have time to talk about enforcement. So let's suppose that you are a litigant in a conventional civil action. You have walked this long and winding road. You have made it to trial. Your case has been adjudicated on its substance, and you succeeded brilliantly. The judge and the jury bought everything you were selling on that day. They issue a judgment saying that you're entitled to everything that you were seeking in your statement of claim or in your counterclaim. Okay, so that's great. That's happened. The other side says they won't appeal. Now, sometimes words from a judge are enough. The vast majority of plaintiffs don't bother walking this long, winding, expensive, arduous road just to have a judge say something. They want something to change in the world. They want someone else to be compelled to do something through an order. And very often, so sometimes that's an injunction, stop doing something, start doing something. Usually that's what people are most often suing about. So we require something more than just judicial words. And this topic of enforcement is all about how we turn judicial words into reality. The first step in enforcement is getting a court order. So what you've read mostly so far in law school, perhaps entirely, is judgments, right? So you know what judgments look like. An order is different. And what an order is a specific set of judicial instructions about what to do, right? So it's a document which bears the authority of a court, which creates legal obligations and legal rights. An order is not judicial reasoning, right? In an order, you will not find references to cases, you won't find certain streams of authority being distinguished, you won't find all those moves that you've come to expect in judgments. It's a quite detailed definition of what parties should do. So you'll see a lot more detail. So here, for example, this is a court order in an estate matter where it's basically the court telling these litigants who are fighting about a will about what to do going forward with the property of the deceased. And the order will be very detailed. So here, there was this land that was at stake, this piece of real estate. And so this is a very detailed description. So this is the legal description of this property of 610 Delaware. And it's provided here in total detail to render it absolutely clear what they're talking about and to minimize and hopefully completely eliminate any chance of disagreement about what the parties are supposed to do, because one of the parties is supposed to sell this. So a judicial order is not written by a judge. Typically, it is drafted by the parties sometimes after a judgment is given. So if you ever think, like if you just think about one of the judgments that you read in one of your other cases, very often, and you just think at a nitty-gritty level, okay, what do the parties do the day after that judgment is issued? You know, who does what, who puts money where? The parties will typically draft an order after a judgment is given, which reflects the judgment, and then they'll bring it to the court to be signed and issued by the judge. Sometimes there will be no judgment. Sometimes the parties will enter a consent order where they draft something like this together, and it's issued by the court to give it the force of law. So sometimes you'll bring it in. In this case, the parties drafted this together, and then they may have decided, well, we don't really want this anymore. This isn't practical, so one of the parties crossed this out and the other one signed it. It's also possible the judge crossed this out, and that's the judge's initials. And then at the bottom of the order, you'll often find, so here they're being ordered to engage in mediation to try to resolve it consensually. Orders that the issue to be tried by a judge without a jury, and then costs. So costs we'll get into next week, but costs are at the discretion of the court. How much are we going to pay to the applicant because the respondent basically lost on this motion? So the judge, this was left as a blank line, so the judge can write in, I think the applicant should have to give, the respondent should have to pay an extra $3,500 to the applicant to compensate them for the inconvenience of having to do this. Okay, so you're trying to turn the beautiful judicial words into reality. The first step is to get an order that says exactly who is to do what, when. And hopefully once you have this, your adversaries will voluntarily comply, right? And sometimes they will. But sometimes that doesn't happen, right? Sometimes the court order is not enough and you have to take further efforts to enforce. And that's what this is all about, right? So enforcement in cases where you don't get voluntary compliance after the court order, it's kind of like a sort of a mini bonus round of civil procedure that you have to go through in order to get reality changed in the way that your client wants it changed. Okay, so a couple readings about this. You have Courts of Justice Act here, a few provisions, it's directed it can be directed to a sheriff. A sheriff is kind of a police-like officer whose role it is to enforce court judgments, enforce judgment debts. So the sheriff has it. That doesn't necessarily mean the sheriff is automatically going to take it upon themselves to satisfy your intent. The police have to help them and so on, but further steps have to be taken. What else do we need to say about this? A bond or a recognizance, this is kind of getting into the weeds here, but where someone has made a promise in a proceeding which has the force of law because a court order has given it that effect. Okay, so how do we actually make this happen? So the one we talked about, the enforcement mechanism which we've talked about already, is contempt of court, Rule 60. We talked about that in the context of Henko. And if a court has made an order, like this one, or like those injunctions issued in Henko versus Denisani, and a party willfully disobeys it, then that party is in contempt, and you can bring that contempt proceeding. Now, contempt has one sharp limitation, which prevents it from being used in most cases. Does anyone remember what that is? Why it is that this contempt power, although it is a form of enforcement, is useless to most plaintiffs in most cases? It's this. Can't use it to compel payment. Rule 60.11. You cannot use contempt to compel someone to pay money, even if a court order orders them to do so. This was not always the case. It used to be quite common to use contempt proceedings, and contempt proceedings, you recall, carry the threat of imprisonment. We used to have this, and that led to debtor's prison. If you read any Dickens or any sort of 19th century accounts of the legal system, this was quite common. People would be unable to pay debts. Their creditors would get court orders saying they had to pay, and if they didn't pay, they were imprisoned until they did pay. This was considered outrageous and a form of penalizing poverty, so we got rid of it. So no more debtor's prison, and if we're not going to have debtor's prison, and we are going to have imprisonment as a contempt consequence, it follows that we can't use contempt for orders involving the payment of money. So we have to look at other mechanisms for enforcement. Some of them are here in Rule 60. We have the writ of seizure and sale, Rule 60.02 sub 1. That basically means you can get an order saying the sheriff can go and take the other side's stuff and sell it and give you the money. The appointment of a receiver usually arises in bankruptcy. So if a corporation owes you $100,000, you've got the judgment, you've got the order saying that they owe you $100,000, but that corporation is basically circling the drain. They may be insolvent. They've got a bunch of other creditors. Then this is basically a way to drive them into receivership, which is sort of like bankruptcy. And then you will have a chance to get as much of that 100,000 as you can. And then we have garnishment. So garnishment is a very important one. This is our dictionary definition of garnishment. It's where effectively a third party owes money to someone who owes you money due to a judgment and an order. And garnishment is basically an order that says to that third party, okay, instead of giving that money to the person to whom you owed it, give it to me instead, because that person to whom you owed the money owes the money to me as the result of a judgment. Okay, so this is what garnishment is, a very important one, very often used if there's a bank account, right? So if the person who owes you money as a result of a judgment has a bank account, you can garnish the amounts that the bank owes to that person and redirect that debt to you instead. So Jantunen tells us a little bit more about garnishment. So Edwin and Lillian Jantunen are parents of Layla. Layla marries George Ross. Layla and George split up. And Edwin and Lillian, the parents, are now suing George Ross, their daughter's ex, in order to get this money back. So family law cases often arise from similar sorts of facts, right? Where parents of someone who's about to be married often provide money to the happy couple, often for the purpose of buying a home. And the parents envision many years of conjugal bliss and grandparents and all the rest of it. So the parents write a check to their child and to their child's spouse jointly. They get married, they buy the house, time passes, they split up. The parents who loaned that money still probably want to help their own child out, but they have no interest whatsoever in helping out the ex. They want to get the money back, right? So what can the parents do? Well, they can say that this money was a loan. When we provided the money to buy the home, we were loaning the money. Because if you say it's a loan, that means you can enforce the loan against the ex and then get the money back and either keep it or give it to your own child to buy a new home or for whatever purpose. So the parents will often or the parent will take the position that this money that was provided was a loan. But the reason why this is so often litigated is because very often it's not papered, right? The money is simply at the time of the marriage or the time when the couple is going to buy the home, the parents just provide the money and they don't talk about whether it's a gift or a loan. And if so, then the ex, what will the ex say when the parents try to get the money back? That's right, they'll say it's a gift. And if it's a gift, then it can never be recovered. And then the courts have to try to go back and determine the intent of the parent or the parents at the time when the money is provided. Was it a gift or a loan? And it can go out of the way. Here, Edwin and Lillian Jantunen were smart, or they had good advice. They papered the transaction, what you should always do if you're in their position. They made it clear that this is a loan. They have this promissory note signed by their daughter and by George Ross that says this is a loan. Now, if the kids had stayed together, the promissory note would have probably just lived in a drawer collecting dust and never been collected on. But because they've split, now they can enforce it. So they easily get judgment on this against George Ross. So George is going to have to, there's a court order, a judgment saying George owes this money. We move to the enforcement proceeding. A contempt proceeding is out of the question because it's money. And the writ of seizure and sale, maybe, right? I mean, you might get his moped, but most people don't really have much property of any value, and then you have to resell it. It's a hassle. So we move to garnishment. They want to garnish George's wages. And George Ross, that is, works for Vincenzo's Italian restaurant. He's a waiter. And as a result of his employment there, Vincenzo's, the restaurant, becomes indebted to Ross every 2 weeks for his wages. So that means the restaurant is a third party within the definition of garnishment. They owe money to Ross, who owes money to the Jantunens. So they want to garnish that money. So George is paid an hourly wage plus tips. And what's the problem? Why are they not able to just take all of his money, take all of his wages, everything that Vincenzo's restaurant owes him, until every penny is owed? Okay, so tips are there, but before we get to the tips, there's a statutory provision which partially protects Ross from having his money. It's this, right? The Wages Act, not that, this. The Wages Act, 80% of a person's wages are exempt from seizure or garnishment, right? So a major curtailment to the garnishment power. So this is there to protect the incentive of judgment debtors to keep on working. Because if the law said, okay, as soon as someone owes you money, you can garnish the entirety of their wages, and every penny that they would have earned goes to you instead until the debt is satisfied, these people are going to quit their jobs en masse, right? So it's not just the first 50,000, it's actually the first 80% of your wages. And if you're earning $500,000 a year, 400,000 are still protected. And that's supposed to be the law's way of protecting, ensuring that you still have an incentive to earn. If it's just a bank account or some other asset, you can garnish the whole thing. So this is just about wages. Okay, so this is clear law. The question is, what about the tips, right? Are the tips wages? Because tips, of course, are where the money is if you're a waiter. And if the Jantunens are only able to garnish 80% of the wages and the tips, that's not as good as being able to garnish to collect the entirety of the tips. Okay, so the lower court said that this definition of wages for this purpose includes credit card gratuities. That's what the lower court said. So why are we only talking about credit card gratuities here? Why aren't we talking about cash tips? The real point is that cash never goes through the hands of a third party. You can't garnish cash tips because garnishment by definition requires a third party. The restaurant, the employer, never has the cash tips, so you can't garnish them. Okay, so the question here, so if these credit card tips, they could in principle be garnished, but if they're wages, then they are 80% protected. If they are not wages, then you might be able to garnish the entirety of the credit card tips because they still go through the restaurant, right? So the third party still possesses them. Okay, so there's some arguments here about the Income Tax Act, an argument which is ultimately rejected. The Jantunen say that these credit card tips can't be wages. They can't possibly be wages because it's not money. The credit card tips, it's not money that the restaurant pays to Ross, right? The money comes from the customer, so it can't possibly be wages. Therefore, the Jantunen say it can't be protected by this 80% thing. The court ultimately says no. The court says that the point of the Wages Act, the point of this exemption is that we want to give people a continued incentive to keep on working, and we don't want to deprive people of the money that they live on. We don't want to impoverish people as a result of this garnishment enforcement process. So the court ultimately says that because when you're wait staff, most of the money comes from tips, we've got to extend this to tips as well. Because if we didn't, we'd be defeating the purpose of Section 7, Sub 2. And that cannot have been the intention of the legislator. Okay, so there's interesting reasoning in the case, but that's the bottom line. Okay, so that takes us to 650. Thank you for being with me today, and have a great weekend.